Hi, welcome to Coffee and Chatter. This is part of my series called It's the Constitution, Stupid. This is actually volume 5, and I've entitled this one Constitution 101 and the Bill of Rights 101. So let's go back, way back. Back in the early 1770s, in the run up to the Revolutionary War, no patriot leader was saying that there were limits to free speech. No patriot leader ever uttered the nonsense that free speech was not absolute and then used the argument that one couldn't shout fire in a crowded theater. The English? Yeah. I'm sure the English leadership wanted free speech shut down. In fact, the English wanted to shut down the churches because the American pastors were preaching what they considered, what the English considered, incendiary sermons about liberty, inciting the American populace. Now, likewise, no American patriot ever said or thought that the God-given natural right to keep and bear arms wasn't absolute, but rather had limits. Nor were the leaders of the newly established republic saying anything like that in 1887 as they were gathering to write the Constitution in Philadelphia. In fact, 10 years earlier, they fought a war over it, part of which involved preventing the English army in its attempts to seize American armories to prevent the Patriots from having access to firearms and munitions. Can't fight a war without them. So let's do Constitution 101 followed by Bill of Rights 101. The United States Constitution, this is a quote I read somewhere, was written to set forth the essential infrastructure for a new centralized government and to establish, underline here, very clear boundaries for that government. If you've read the Constitution, it will be clear to you that the powers of the federal government are not unlimited. In fact, the purpose of the Constitution was to define clearly the limited powers of government. The Constitution defines the powers of government as few and defined. The power of government, in fact, rested in the people. And the rights of the people and the individual states were many and without limit to speak of. So to clarify the difference between the rights of government and the people, the framers defined what I think those differences were in the 9th and 10th Amendments as they rounded out the Bill of Rights. In the 9th Amendment, they said the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, do not let it be thought that the enumeration of a very few, very important rights here in the Bill of Rights is meant to exhaust the list of rights held by the people, which are in fact too numerous to list. Now, they then put the stamp on that with the 10th Amendment to address the other side of the house. The power is not delegated to the United States, which is the federal government, by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. That's the 10th Amendment. So there's something in there that might confuse, but I'm going to clarify. In other words, any authority that the federal government attempts to appropriate to itself that is not specifically listed in the Constitution doesn't exist. Furthermore, all powers not specifically delegated to the federal government are in fact under the purview instead of the individual states and the people therein. And here's the key: unless specifically prohibited to the states. Now, what does that mean? let me address that. Not nor prohibited by it to the states. What exactly is that? Let's use the most contentious of issues to shed light on this idea, which is the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Did the framers establish the right to keep and bear arms? Was that a theretofore unknown right? Okay, before we go there, in the Second Amendment, the framers took it upon themselves, lest in future times, and this was the fear, some would forget. So they took it upon themselves to restate that the sacrosanct right to keep and bear arms was a God-given right, and the government had no right to infringe on such rights. Now, that statement appearing in a federal document, the Constitution, seems to me to fit the bill of answering the question of what was prohibited by the Constitution to be under the purview of the individual states. The right to keep and bear arms was understood to be a God-given right. It preceded any government, any document of the people enumerating rights, and certainly the establishment of the individual U.S. states and the voluntary federal government they agreed to participate in. The individual states, therefore, have no right to infringe upon our right to keep and bear arms, as much as they have no right to impose restrictions on free speech, religion, or the freedom of the press. First Amendment, quartering of military personnel in private homes. Third Amendment, privacy against search and seizure. Fourth Amendment, and due process. Fifth Amendment. Those rights are God-given and therefore outside of the realm of both federal and, here we go, state governments. So to me, that fulfills the phrase of what's prohibited to the states. They don't have the right to control those. These rights belong strictly to the people and are not to be abrogated by any government. In other words, any attempt to regulate or restrict such rights is forbidden to the states by the Constitution. If there's a problem with the way any particular individual citizen or a group of citizens are exercising their natural rights, the executive, the Congress, the federal government, or the state governments may repair to the courts and have their cause heard there and decided upon based on the merits of such arguments as regards the Constitution. Finally, that brings me to this. You can't say this enough times because people just don't seem to get it. Nothing in the Constitution attempts to establish rights. There are no rights that the government can convey upon anyone. Government bestows privileges upon people. When the government builds roads, forgetting the fact that we actually paid for the roads, roads were built with taxes placed upon citizens. But in such a case, the government, takes upon itself the ability to grant or deny Americans access to the roads. In other words, a privilege to operate a motor vehicle on those roads. You gotta fill in all the boxes. Now, on your private property, government possesses no such authority. No one can grant or withhold the privilege of driving a motor vehicle upon one's own property. That's not a privilege. That's a natural right and does not fall under the purview of the federal or state government to regulate. In fact, the Constitution mandates that government is established to protect our rights. The right to do as we please on our own property being one of those rights, otherwise known as the right to life, liberty, and the pursuit of happiness. So here we go. The idea that Americans have a Second Amendment right to keep and bear arms is an obfuscation and a smokescreen. The Second Amendment is a mandate to government, not to infringe upon the God-given right to keep and bear arms, not to establish any such right. So it is likewise with all the natural rights of Americans, enumerated in the Bill of Rights or not. It's not that hard to figure out. Whatever authority the Constitution relegates or delegates to the federal government is the purview of the federal government. Everything else belongs to the people. That's it. Constitution 101 and the Bill of Rights 101. If our elected officials ever took time to read our founding documents that they all took an oath to uphold and defend with their right hand raised, we'd all be better off. Hey, thanks for listening today to Coffee and Chatter.